Price. Here's Craig Ashton.
Good morning, Sacramento. Welcome to the show, which is called All Things Legal on Money 105.5, the Wall Street Business Network. Essentially, this is a show, if you've never joined us before, where personal injury attorneys, because that's what we do for a living, or as William F. Buckley might say, in the way we earn our crust. And basically what we do is we're curious and we distill topical events into their legal essence. And what does that mean? Well, hopefully we'll improve your Jeopardy game, at the very least show you the legal foundations of stories that you're probably aware of but haven't been fleshed out from the perspective that we're about ready to flesh out for you. I'm joined this morning by my colleague. Yesterday, when we celebrate good things in our office, we bang a gong. And yesterday, Ed had a 5-gong day, so we call him the Chuck Barris of Ashton and Price yesterday.
Which was kind of funny because I had to ask him who the heck Chuck Barris was.
It was Ed's gong show.
I forgot about the gong show back in the, what was it, 80s or 70s?
Ed received a fantastic Yelp review basically saying that this individual made one of the best choices she's ever made as a result of choosing Ashton and Price to get her through the vagaries of the personal injury process, and spoke specifically about Ed and how great her experience was with him. So he got a gong for that. And then he resolved a case for $425,000, a disputed case, almost $447,000.
Correct.
Battled just before trial. Great result. So, Ed, congratulations.
Muchas gracias, senor.
Con mucho gusto.
Sí.
All right. So, basically, this morning, and Denise, your lovely wife, who I think you've traveled before, and people thought that she might be your daughter.
Yeah. It was actually, we were on vacation. It was pretty funny. Because my wife looks like half my age. Somebody goes, would you like a picture with your daughter? And I turned around and I said, want to show them how you kissed Daddy back in the States? She just looked at me like, what are you doing?
So if you're curious, you can go to ashtonandprice.com and see the silver-haired gentleman, Edward Sade. You can also get a look at our bios and take a look at what we do from a personal injury perspective. But today, per Denise's direction, which I think is very good, we're going to cut straight to what we're going to talk about today.
She kills me when you do that.
but it's super good advice, and it's genuine, too. All right, so we'll go ahead and distill and break down what's going on with Donald Trump and the lawsuits that have been talked about in regards to Trump University, which is now called Trump Entrepreneur Initiative. There's 3 different lawsuits, one by the Attorney General of New York and then 2 other class action suits brought in California. We'll break those down for you. We'll break down a Audi verdict in Texas, where in San Antonio, a jury awarded an 11-year-old boy $124 million as a result of brain injury that was sustained, in the opinion of the jury, as a result of an Audi A4 seat buckling, causing his father's head to come in contact with his head, left him with serious brain damage. The jury came back and found Audi 55% responsible. We'll break that down for you. The interesting thing is we have a case right now, a very similar case against a large automotive company, and we're moving towards trial. I'm working with a colleague and friend who's associated with our office, Brian Chase, former president of the Consumer Attorneys of California, trial attorney of the year. I was president of law school at Pepperdine, and he was always into politics, so we became friends that way, and he's turned out to be one of the best products liability attorneys in the country, and we work with him. And we had the pleasure of watching him give a closing argument against Audi, same company, Volkswagen AG, with his client was paralyzed from the chest down as a result of, in his opinion, a faulty seat, which basically collapsed, changed the center of gravity to his thoracic spine. And it was a battle of experts. He spent about $800,000 on that case making that presentation. And Brian fights a good fight.
The jury's still out, it's my understanding.
Jury's still out. He asked for $23 million. And it was a great closing argument, so we'll break that down for you. But as plaintiffs' lawyers go, people make fun of us, right? But from a plaintiff's perspective, and our producer, G, is chuckling. I'm pretty sure G's a pretty conservative guy, because anytime I ever talk about Clinton or say anything derogatory about Ted Cruz, he starts shaking his head. So
email.
I'm pretty sure he doesn't like Hillary Clinton too much. But the point is that Brian and people like us at Ashton Price, when we take a case to trial, if we lose, we don't get a dime, and we also eat all of our costs. So in this case, Brian is exposing himself to $800,000 in costs for the experts, recreating the accident, etc., to represent his client who's paralyzed from the chest down and his wife, who is a lovely lady. And if he loses, he's out all of that money and all of that time. Obviously the individual is paralyzed, and that's a cross that is much harder to bear. But the plaintiff's lawyer has a lot of skin in the game, and so we'll talk about what happened with Audi and how that applies to the recent case in Sacramento, which is the similar case and same defendant and similar arguments regarding a seat collapse. We'll talk about the Aaron Andrews case, a $55 million award. Aaron Andrews, if you've been in Bangladesh for the last year and you haven't been following the news or you don't like sports, she was a sideline commentator for ESPN. She was staying at the Nashville Marriott at Vanderbilt University. An individual who was stalking her found out her room and took out her peephole with a hacksaw, put his phone on it, and videotaped her for 4.5 minutes in the nude, put it on the internet. She sued for $75 million and named the Nashville Marriott, West End Properties, and Windsor Capital Group as defendants. Jury came back, and we'll talk about that, and we'll talk about how the jury got to their conclusion. She was awarded $55 million, and we'll talk about how the jury got to that particular outcome. Just as an aside, I don't know how much we'll delve into this, but we'll just lay it out now. If you watch Pawn Stars, it's on the History Channel.
Oh.
It's pretty funny that History Channel really doesn't have any history anymore. I mean, I don't know what Pawn Stars has to do with...
Well, they bring in old things, and they talk about the history of the item, I assume.
Right. So Austin Lee Russell, who's better known as Chum Lee, was accused of sexual assault. So a search warrant was issued and went into his house and, found some methamphetamine, some marijuana, and at least one gun. So now he's being charged with some felonies, 19 drug possession charges and 1 weapon charge. Guys like him, I pass through the show, and I actually find that guy relatively entertaining. I don't plan my day around it, certainly don't TiVo it, but guys like that, and then the Jared from Subway, they got hit by the lucky financial stick. Dude, just show up to work, be slovenly, celebrate the fact that you either lost some weight or you're able to ascertain the value of a 1860s
Well, it's just kind of surprising that he got caught with meth and how heavy he is.
I know. And you just can't let the universe embrace you with this warm, fuzzy feeling of success that you probably didn't earn, and you got to go ahead and do something stupid like that.
Well, it's just the universe making things right.
Yeah, probably. And then if we have some time, we'll go ahead and talk about the court rejecting key lawsuit brought by some plaintiffs on the high-speed rail. Essentially what the judge says, look, as it stands right now, the money that was approved in Prop 1A for the bonds is not actually being used for the high-speed rail yet, so any sort of challenge is not ripe. And we'll talk about what the requirements are for the high-speed rail. So once money's being spent, then there probably is a strict compliance requirement where it's got to get to L.A. I think from L.A. to San Francisco in 2 hours and 40 minutes. It's got to get from San Francisco to San Jose within 30 minutes. It's got to be viable. Every train's got to operate every 5 minutes in each direction. There's no subsidy. And there's other requirements, and if those aren't met, then you're probably misusing the public funds, and it's going to be troublesome. But the problem is going to be is once it gets going and they start spending the money, how are they going to shut it down? The horse is already out of the barn, right?
Yeah, and that's the problem. It's like anything. I remember my brother used to go on and do business reviews, and some CEO would have his pet project, and they'd come in and tell him, hey, this is a boondoggle and a waste of money, but they would keep it going because the guys go, well, we're already into it, so we're going to just keep it going down the line. And they're going, cut it off now and just start over, and you'll be much better off. But people won't do it, and I think got the same problem here.
Yeah, well, the bottom line, I'm not going to take a position. It's just that the bond was passed. California taxpayers passed it, California voters passed it, look, we think it's a good idea. So now the money's got to be spent within the confines of what the voters agreed to, and if you start spending on other things, then legally speaking, they could shut it down. So that's going to be an interesting debate. So when we come back from the break, we'll go ahead and talk about Donald Trump. I read a National Review article, and this is William F. Buckley, who I really loved. When I was growing up, when I went to Berkeley, I was kind of like that kid from Growing Pains, I think it was. Not Growing Pains. Who's the one who wore the blazer?
What you talking about, Willis?
No. Well, anyway, so the bottom line, I used to wear blue blazer when I was at Berkeley, kind of conservative. William F. Buckley was somebody I really
Alex P. Keaton.
liked. Alex P. Keaton, right. So we'll go ahead and talk about what the National Review had to say about Donald Trump and the lawsuits. And this is William F. Buckley, founded that in 1955. We'll do that after the break and break down all of the issues you need to know about what's going on with Trump University. This is All Things Legal, and I'm Craig Ashton, joined by Ed Shady. We'll see you in a minute. All right, we're back. This is Craig Ashton. This is Money 105.5, the Wall Street Business Network. The show is All Things Legal. I'm joined by my colleague, Edward Sade Shady, who's a fine trial attorney. Had a
Sacramento.
A metaphorical 5-gong day yesterday as a result of a great Yelp review and a $447,000 resolution on a disputed auto case. So great work, Ed.
Gracias.
Con mucho gusto. All right, so when we took the break, we told you that we'd be talking about what's going on with Trump University and the lawsuits that you've heard so much about, and kind of break it down for you so you understand it better. William F. Buckley, who's somebody that I really liked growing up, back when I was 10, 11, 12, I used to watch Firing Line. When I went to Berkeley, Reagan was president, right? I would wear a blue blazer and kind of antagonize people with a little bit of a conservative approach to things. And, William F. Buckley would say things like, if somebody disagreed with him, he would say, "I'm not going to impugn your intellectualism to suggest that you believe that which you just uttered." So now we've got Trump, who's leading the Republican Party, who used to be led by people like William F. Buckley, who's talking about little Marco and Lion Ted, and they're debating about who's wetting their pants and what the euphemistic understanding of small hands is. And I don't know. I've never seen anything like that. I prefer the William F. Buckley approach. It takes a little bit more time to understand the concepts, but when you get to the end of a little bit more trying journey, the satisfaction that comes with that enlightenment certainly is much better than basically debating on who's urinating themselves, right? So basically the National Review had a pretty interesting article about what's going on with Trump. And the reason I brought up William F. Buckley is because he founded the National Review in 1955. And if you want to see this guy, he has some debates, William F. Buckley, I think, with Gore Vidal. Very interesting on Firing Line. And you can get it on YouTube. And if you want to see the height of the intellectualism of the Republican Party, when ideas were, nuanced and it wasn't just battering you over the head with broad statements like, let's ban all Muslims and, just broad things. And these are things that are more nuanced because there are very few times that a broad answer is always the right answer. So anyway, William F. Buckley in National Review talked about the 3 lawsuits that are occurring against Donald Trump. 2 of them are class action lawsuits filed in California, and then one was filed in New York by Attorney General Eric Schneiderman. There's a recent case in New York where they upheld standing, so saying that the Attorney General's office in New York had the right to sue Donald Trump University, Donald Trump, for fraud, and then also said they were timely. There was a question as to whether or not the statute of limitations had expired, and Donald Trump argued that it was a 3-year statute of limitations. The Attorney General's office in New York argued that it was a 6-year, and the court agreed that it was 6 and said, therefore, it is a timely filing, and therefore it's not barred by the statute of limitations.
Yeah, which was kind of surprising. In California, it's a 3-year statute of limitations for fraud. But what I thought was interesting, and I can imagine it's going to be a counter to the attack ads, if I'd actually ripped you off to the extent that you said, and I took all this money from you, why did it take you over 3 years to finally file a lawsuit to come after me to get it back when I've always said, and standing in place for Trump, and I've always said I'll never pay anything back because I didn't do anything wrong. So it's kind of interesting that it got that far. Why wait?
So here are the allegations on both sides. The class action suit in California, what's going on in New York, the arguments are essentially these. They said this was a bait and switch experience where you would pay for, I think, a 3-day seminar. It's like $1,500, and said that these were hand-picked instructors by Donald Trump, which it turns out he didn't hand-pick them. So that's a material fact, right? So
correct.
And that when you say an opinion like this is huge, this is the greatest, you can say those things because it's called puffery. But when you make a statement of fact, it becomes an issue regarding to how you entice these people in, breach of contact, and potentially misrepresentation, which becomes fraud. So the argument is, look, he said they were handpicked. Some of the people said that they were under the impression that they were going to meet Donald Trump, which never happened. And it also said that these people are real estate experts, and it turns out many of them, at least according to the allegations, had no real estate background. They were actually motivational speakers, and they were paid a commission to talk these people into signing up for the next level, which I think was like the platinum status or something, which is something like $30,000.
I think it was 35, but yeah, fraud. It's got to be a misrepresentation of a material fact. And when you get out there and say Trump's going to hand select, that may not be material. But when they say it's going to be experts in the real estate field, and then you don't bring in those experts, that starts falling on material. And then there's all other, and especially when you're getting your advice from guys that sell timeshares, which are absolutely pressuring you to get in there and buy something. That's another thing that really doesn't look good for you to the Donald.
My beautiful, erudite, bilingual, and very sharp business-wise girlfriend, Tanya, signed up for something very similar recently here in Sacramento for these guys that do flip houses on, I don't know, it was A&E or something like that. And so, she went in because she wanted to find out how this worked. And next thing you know, it turns into a hard sale where, yeah, guess what? Thanks for the $200, but hey, if you give us, I think it was $50,000, we'll give you an inside track. And I said, bet. Now we are getting real. And this is, clearly they're there to sell you something. They're not there to give you ideas to make you successful. They're there to sell you their idea to make them successful.
Yeah, it's funny about that.
And she stopped going, so we had a great day. We went for, went to Copperopolis, and we actually explored a little bit and had a very nice lunch. And now they're calling her on their cell phone. They won't leave her alone, right?
Yeah, I'm sitting there. I'm going to bring in a class to teach you how to make money on how to sell realty, but I'm making a ton of money on getting money from you on how to teach you to sell realty.
Well, you know who made the most money during the gold rush? The people that sold the equipment to the people trying to find the gold, right?
And Levi Strauss.
Right. So these are people that are trying to sell the equipment to find the gold, which is real estate riches, and they're going to win no matter what. So if you give them $50,000, doesn't matter if you find gold or not, they've already got theirs.
That's a great analogy.
Yeah, it is. Not bad. Hey.
Especially we're in the gold country.
I think I get a gong.
There you go.
Figurative gong. All right. So basically Trump's counter argument is this: look, first of all, I never said you're going to meet me. Second of all, you didn't work hard enough. So I gave you some tools, and guess what? If you are not one who's going to commit to the experience and take the information I've given you to succeed, that's not my fault. And I can figuratively lead the horse to water, but I can't make you drink. And he says, look, there's 98% of all of the reviews that I got are positive. And a lot of the people that are suing him actually said this was a great experience. One of them is a yoga instructor in San Diego who now wants out. She says, I've had enough of this. It's too much. I've been through the ringer. This is not conducive to me enjoying my life. And I no longer want to be a named plaintiff in the class action as a representative of the class. And she wants out of the lawsuit. And Trump has taken her deposition, I think, 4 times now.
Well,
over 16 hours. Sued her for defamation for $1 million, which she was able to prevail on. And the court ordered him to pay $798,779 in her legal fees. And now she says, look, I just can't take this anymore. This is going to trial probably sometime this year. There's a trial setting conference, I think, in May, right?
Yeah, it's in federal court, I believe. So it's already had a trial date set. I think, yeah, he's going to have to testify during the electoral process.
So she's just saying, look, it's not that this case doesn't have merit. It's just that the stakes and the way that this is approached is too aggressive for me, and I just don't want to participate in the process anymore. And Trump says if she's out, the rest of the case needs to be dismissed. So I don't know what's going to happen there. I don't think they're going to dismiss the whole case if she gets out, because they've already let 2 other plaintiffs out, and there's still 2 others that are representative of the class. But his argument is say, hey, look, bottom line is, gave you the tools. You didn't make them work. That's not my fault. And when I have 98% of the people saying, including you, how great this experience was, and she says, hey, the reason I filled out the surveys this way is I didn't want to risk alienating anyone who might advance my career. In other words, I've got $60,000 invested in this thing. I'm not going to say you guys are a bunch of idiots because I'm still hoping you might help me.
Well, think about it. Even from a psychological point of view. You go and dump a ton of money in something, and your friends goes, "How was it?" "Oh, it was awesome." You're not going to tell them, "Hey, I just got ripped off," and feel like an idiot. So you have to some degree, if you're going to spend that kind of money, back it so that you can just self-justify it. But there's an age-old saying: "A fool and his or her money are soon departed."
Yep, I agree. So it'd be kind of like the captain of the Costa Concordia, I think. Who,
Yeah.
He somehow he was one of the most lucky individuals on the planet. When the ship that he was captain of started to list, he was forced off due to gravity into a lifeboat.
He fell off into a lifeboat, and then when he was ordered to get back on the ship from
if you're one of the passengers, you're not going to berate the guy at that time because you kind of want to get to shore yourself. But once you're there, you might be critical. So the point is that I can understand if she's got $60,000 in the game and she's still not to the metaphorical shore. She's still relying upon these guys to help her, figure out this real estate game. And when she realizes that ain't going to happen, and the captain metaphorically is actually in a cafe watching the ship sink, at that point you say, "Look, I know I wrote some nice things about my experience, but now that there's it's an equal playing field, I'm going to tell you kind of what I really feel." So that's what we're dealing with. I don't know how that's going to end, but I just don't think. For whether or not it's illegal, it doesn't seem to me to be a business model I would follow.
Oh, God, no.
It's Craig Ashton University. You never meet with a lawyer, people that don't really understand the law, people that don't even have a law background. You never get to meet with any attorney. You don't get to meet with me. And
I hate to say this, but it sounded shady.
And then the great thing is, you see all those pictures. If you want to go on the internet and look at it, these guys are taking pictures smiling from ear to ear next to a cutout of Donald Trump.
Hey, why not?
Persuasive. So when he says he can cut good deals, he is not joking. So, maybe he will be able to get Mexico to pay for that wall. He is pretty persuasive.
Or he'll just get a cutout of a wall and put it up there.
Exactly.
Them standing next to it or on top of it at the parapet.
So those are the Donald Trump lawsuits, and they're civil, right? There's no criminal attachment to any of these things. It's all money damages, and they're saying it was $40 million that changed hands in New York that they want back. And then $5,000, if it's $30,000, what is that, $15 million?
Yeah. Quite a bit.
So yeah, it's a lot of money involved here. Really, he could settle these things. If it's true that he's worth $10 billion, a drop in the bucket for him. And I'm not sure that he knew how well he was going to do, but looks to me, especially if he beats little Marco in Florida, and
the pejorative, little Marco.
Well, that's just that's what. He
hasn't. I was listening to the radio coming in on it.
Where's the William F. Buckley when you need him?
Yeah, little Marco's down 20 points in his home state.
Well, we won't impugn your intellectualism to suggest that you believe that which you just uttered. When we come back, we'll go ahead and talk about this Audi case, $124 million verdict in Texas, and we'll do that after the break. This is Craig Ashton on All Things Legal. All right, we're back. This is Money 105.5, the Wall Street Business Network. You found yourself smack dab in the middle of a show called All Things Legal. My name is Craig Ashton. We are personal injury attorneys by trade at Ashton & Price, and if you're interested to see what we do, go to ashtonandprice.com, and you can see our website with our bios, etc., and see how we have gotten to this point in our professional careers. And you also can put a picture to a voice. I'm joined by my colleague, as is customary, Edward Shady.
Hey, good morning, Sacramento.
And we just got done speaking about Trump University and the fraud cases, which are civil, so there's no criminal attachment. I think last night in the debate with Hillary Clinton, the representative was at Univision, I think it was, said, if you get indicted, will you terminate your campaign? And she says, I'm not going to happen. That won't happen, but it could. The legal system is unpredictable. I'm sure O.J. Simpson killed his wife, and he got acquitted. And
the question was kind of vague. So, would you quit your campaign? She can still get indicted and say, no, that ain't going to happen. I'm going to still campaign, or no, I'm not going to get indicted.
Yeah, she said, I'm not going to answer that question. So the point is that could be a criminal issue for her.
Yeah,
which is different from the civil stuff for Trump. And Trump, if he wanted to, he could end this today by basically just making an offer to pay all the damages, and it would be done. So he controls the outcome, whereas when you're being investigated by the FBI, et cetera, the Justice Department, you don't control the outcome.
If she becomes president, then she could pardon herself.
Yeah. Hey, that's a topic for another show. All right. So when we took the break, we indicated that we would be talking about this $124.5 million verdict for an 11-year-old boy against Volkswagen AG and its subsidiary Audi. It was an Audi A4, and the front seat collapsed, and the boy's father slid backwards, hitting his head on his son's head, who was in the back seat, leaving his son significantly brain damaged with significant cognitive deficit. The jury in Texas is a contributory state, which means that if you can prove that the defendant is 50% or more responsible, then they're responsible for all the damages. If you can't prove that they're 50%, so if they're only 49% responsible, then they're not responsible for anything.
That's if it's only two parties. If it's three parties and the person bringing the claim is more than 50% at fault, then they're cut off. But if they're 49 and the other ones are split, 25.5 still goes forward.
In California, it's comparative, so
Correct.
it's a percentage of fault. So let's say you're jaywalking and you get run over and you're 90% at fault, you're still entitled to 10% of your damages. So the percentage of fault does not preclude you from seeking redress. It's just the amount of money that's awarded is altered at the end of the process based upon the percentage of fault. So what the attorney for Audi said is, quote, "It's worth noting that neither the driver nor the injured boy were wearing seat belts, nor was a boy seated in a booster seat," which I think's got to be considered, right? Because if the seat collapses, that's one thing. But if dad's wearing seat belt, the question becomes whether or not for the jury, even with the seat breaking, the father's head would have come into contact with the boy's head, especially if the boy's wearing a booster seat, because that raises his head level up as well. And the jury came back and said, you know what? We looked at all of those issues, and we found Audi 55% of fault. 25% of the fault was at the person that rear-ended the vehicle, and then 20% of the fault went to the father.
Yeah.
And so at that point, Audi's on the hook for the entire $124.5 million. The reason that this is an interesting case is, one, that you really need to pay attention to this because the National Highway Transportation Safety Administration, their requirements are pretty lax. And this seat actually met those requirements, but it collapsed. And apparently it's only a few dollars to fix these seats, and that's all it would cost. But because the requirements are so low, then the issue becomes, if it's meeting federal requirements, should there be liability? The good news in California, and basically in most states, is that the standard is the product more dangerous than a reasonable consumer would expect. And if you're in an accident at 45 miles an hour or less, I think a reasonable consumer can conclude, look, the seat should not collapse. Especially if you're an Audi, you're spending $50,000 on a car. Hey, guess what? You design vehicles. You know what's happening. So make sure the seat doesn't collapse. CD didn't come out of the dash. My seat shouldn't collapse. I mean, because the outcome that in terms of the damages could be devastating like it was in this particular case.
Yeah, I mean, if you get rear-ended at 60, 70, 80 miles an hour, you go, okay, the seat might collapse.
You're lucky to be alive at that point.
Yeah, but if it's on surface streets, it better not collapse because that's beyond the scope. It falls outside of what the reasonable consumer would expect. So it's consumer expectation test. Should it fail at 25? Absolutely not. 35? Absolutely not. 45? Absolutely not. 100? Absolutely, probably. So yeah.
We have a current case in our office, same case. Basically, seat collapsed and little boy crushed his skull. Good news is that it looks like there's no brain damage for our little client. Great news. He's got a massive scar from basically his temple down to his chin and probably will lose hearing in his right ear permanently. But when it comes down to what could have happened, that's relatively lucky. Yeah. And the good news was when the accident happened, it happened right there on the where all the merging occurs, Highway 50 and then Business 80 when you're getting into downtown Sacramento. Mm-hmm. And they were stopped and got rear-ended. Seat collapsed. Mother's seat went into skull of son. And the good news was there was a ambulance 2 cars back that was unoccupied. Got him right into the ambulance, got him to the emergency quickly, put a titanium plate into his forehead to protect, and didn't have any permanent cognitive deficit, it appears. So super, super lucky. But still, a lifetime of scarring, a lifetime of no hearing in one ear. It's a serious, serious thing. And it's our opinion, and we may be asking a jury in the next couple of months whether or not, and it's our opinion, that seat did not perform as a reasonable consumer would expect because it was not a high-speed impact and the seat should not have collapsed. And without that our client would not be injured and have permanent hearing loss. Ed and I, we got to watch our colleague, friend, and fellow lawyer Brian Chase, who I went to Pepperdine with. He always wanted to be a plaintiff's lawyer. He was an actor and then decided that he wanted to basically do something a little bit more fulfilling. And he is one of the very best products liability attorneys in the country. Just 2 days ago, a $24.7 million verdict against Ford for a seat collapse case was upheld by the appellate court because he argued, look, the standard should only be what a reasonable consumer would expect. The cost-benefit analysis makes it a negligence case, and this is a strict liability case. And the court agreed. So that is now settled law. Brian Chase is responsible for that. And we got to watch him give a closing argument in a case where his client was paralyzed from the thoracic spine down. What happened was his client was rear-ended. And what happens when your seat collapses? His seat goes back, and it went, in the opinion of Brian and his experts, ultimately the seat went back about 60 degrees. And when that happens, then you ultimately create a separation between the buttocks and the seat. Instead of cupping the individual where all the forces are basically separated out along the spine.
Yeah, being pushed into the back of the seat, it rides up.
Now he's riding up the seat, and the fulcrum point changes because now you're up on the seat, you're going backwards, and the center of gravity is up in the thoracic spine because it's near the headrest. And in that particular case, his client's spine severed at the thoracic spine, left him paralyzed from the waist down. The defense hired an expert from Stanford, and she basically said that ultimately, in her experience, physics dictates that you cannot have forces associated with a rear-end collision when the seat collapses to cause the type of force to injure the spine where it causes paralysis, because all the forces are horizontal. It's going to the head, not to the spine. And then Brian was able to say, well, and that's your opinion. So it could not happen, could not. Well, I'm going to show you a report that I don't think you know that I have, which showed in a different case that very similar impact where the buttocks rose from the seat, causing a change in the center of gravity. You came to the conclusion that that particular case with the separation of buttocks from the seat, changing the center of gravity, led to, in fact, in a healthy spine, paralysis at the thoracic level.
It was his F. Lee Bailey, Mark Thurman moment.
It was a Perry Mason moment. It was beautiful. And going to Cal and she being a Stanford professor was even more satisfying.
I know. All she had to do was just, this has been around forever. I mean, Archimedes, he's written up for the fulcrum, lever, et cetera, and that's what we were dealing with. This has been around for centuries.
So then what happens in that is that Brian went through the jury instructions to say the first question you have to answer is this product more dangerous than you, as the reasonable consumers, the voice of the community, would expect? And if you check yes, only 9 out of 12 of you have to do this, then the next question is, was that failure of the seat, which is more dangerous than you would expect, a substantial factor in causing the harm? Now, the rear-end collision was the first thing. If that doesn't happen, then that's the first harm. But the second harm was the seat collapsing and changing the fulcrum point and the center of gravity to the thoracic spine. So if they answer the first question, yes, the next question is, was the failure of that seat a substantial factor in leading to the harm, which is the paralysis? And if they answer yes to that question, then the next questions have to do with damages. Ned, why don't you go and break the damages down?
I mean, you've got two types. You got economic and non-economic. Economic, straight up, all your medical bills, future care, loss of earnings, everything that you can put a price tag on associated with your life, your 401k accounts, cars, etc. And then you got your non-economic damages, which is pain, suffering, inconvenience, anxiety, everything associated with how this affected your activities of daily living. For being a healthy man that was going out and working in the community. Actually, he was, I think it was the week before, they had pictures of him working on roofs and stuff for almost like...
it was Habitat for Humanity.
Yeah, and then next thing you know, you're in a wheelchair for the rest of your life. So that is a huge change in the activities of your daily living, and the damages are tremendous.
And so what Brian said, which I really thought was powerful, said, look, just retired. He's with his wife of 30, 40 years.
Yeah, it's golden.
And he wanted to finish strong. And then he's now left, and they had a day in the life video that they showed the jury of him being pulled on a leveraged gurney where they have to use gravity to drain his bowels. It takes several hours to do that. Colostomy bag, which has to be emptied every day. A brutal existence. And this guy's dealing with grace and with all the courage that you can possibly bring to bear. But he doesn't want money. If Brian could have gotten him a magic wand that could be waved, that he gets at the end, says, look, you proved your case, here's the wand, you get to walk again, he would change all the money in the world this person would walk away from and just take that magic wand. But because he was in the hospital for 7 months, his medical bill was something like $3 million in the hospital. And then he's got medical bills going forward, which is reasonably certain he's going to need in-home health care, colostomy bags, he's going to need new beds, a new wheelchair over the years, and that added up to another $2 or $3 million. Then Brian, what he said with the pain and suffering, said, look, you are the conscience of the community, and I'm going to suggest this to you, but you can either go higher or lower. That's up to you, that because you are the voice of Sacramento, the voice of this community, to tell this particular manufacturer what damages they owe, and said he would argue it would be $2 million for the first year when he was dealing with the paralysis, $2 million for the year thereafter based upon the fact they had to deal with all these new issues, and $1 million a year thereafter for the life expectancy.
Yeah, and remember the wife, he was married. She also had a loss of
Man,
absorption
and
claim.
great pictures of them, going to Ben and Jerry's with their faces and Ben and Jerry. They're laying on railroad tracks near the skunk train, and they're just living life. They were a cool couple that looked like you would see in a 50s sitcom, right? I mean, it just looked like they really enjoyed each other. Now, boom, completely ended as a result of a day where a seat collapses and he's paralyzed. So the jury's still out, so we don't know exactly what happened in this particular case, and hopefully we'll share this with you next week once the jury does come back. He asked for $23 million, less 50%, because he said, look, I can't tell you how to apportion responsibility. I can tell you we wouldn't be here but for the rear-end collision for sure, but we also wouldn't be here, in our opinion, but for the fact the seat collapsed and it didn't perform the way it should. So reasonably speaking, it'd be 50% each. So they're saying, please apportion it that way, and then the jury's deciding that right now, which is very interesting because it's exactly the same case. It's a seatbelt collapse case, and Brian is one of the greatest lawyers in the United States and in the world at that, and he's working with us on a case right now in Sacramento, which may be going to trial, so we'll keep you in the loop as that moves forward. All right, so when we come back, we'll talk about Erin Andrews and $55 million for invasion of privacy against Marriott, and we'll do that after the break. This is Craig Ashton with Ed Shady on All Things Legal. All right, we're back. Money 105.5, the Wall Street Business Network. This is All Things Legal. My name's Craig Ashton. I'm joined by Edward Sade Shady.
There you go. Joe Jackson there. I love
Into
it.
the night, right?
Yeah.
There we go. This is 80s, I think.
Yep. Right off the Look Sharp album.
Yeah, nice. Like I said, a Renaissance man. He can lay concrete, fix his son's vintage Camaro, and give you a Joe Jackson reference.
I never told him that, Denise. It's your Camaro, not his.
All right. So before we took the break, we were discussing the products liability aspects of seat collapse cases. And so that was a big story yesterday on CBS. And it turns out that we are involved in one of those very cases. I think there was only like 100 of them in terms of seat collapse in minors in the last couple of years. And we have one of them right now that's going towards trial here in Sacramento through our law firm working with Brian Chase of Bisnar and Chase. And so we'll keep you in the loop in regards to his jury outcome on his case against Audi, which had closing arguments last Thursday. All right, so let's go ahead and talk about Erin Andrews. This is an invasion of privacy case. If you don't know who Erin Andrews is, she was a sideline reporter for ESPN. I think now she works for Fox. And she also is on Dancing with the Stars. And the idea is that she was staying at a Nashville Marriott at Vanderbilt, and she had a stalker who was following her around and was kind of obsessed with her. His name was Michael David Barrett. And so Michael David Barrett was able to find out what room Erin Andrews was staying at the Marriott. He claims that ultimately he used the house phone in the lobby, and because it was a house phone, when he asked for to ring her room, the number showed up on the phone. So he had to use some guile to get this. There were other arguments to say that basically the staff gave him the information, but at least his testimony, as far as I can tell, is that he got it through improper means. It wasn't given to him voluntarily. He used his understanding of how the hotel business works to get location of her room. Once he found out where it was, he took a hacksaw to her peephole, removed it, and when he heard her in the shower, and then when she got out, he used his iPhone or his cell phone to videotape her for 4.5 minutes. He tried to sell it to TMZ, and they said no, so he put it on the internet. and millions of people viewed it. And so Erin Andrews, at that point, her career took off. I mean, it was kind of the Kardashian effect, where all of a sudden people who didn't know Erin Andrews now knew her, and she started thriving financially. Her career took off. But she said, look, this is a massive invasion of my privacy. And her attorneys asked for $75 million. They couldn't present a lost income claim because her income actually increased after this. So this was all general damages, which is the fright, anxiety, depression, etc., of having your naked form put on the internet against your will. And what they were saying was it's not only Michael David Barrett's fault, because he did this intentionally. And if Michael David Barrett is Ross Perot Jr., he probably has enough money to pay this, and you probably just sue him directly, right?
Ross Perot Jr.
Or somebody who's got lots of money who can't file for.
Ross is too short to even get to the people.
So you get the point.
Yeah.
I mean, if independently, if this guy's a billionaire, you sue him probably directly, and Marriott doesn't really get brought in.
Well, the interesting thing is, because this guy, it was a criminal act. Typically, a criminal act is a superseding intervening act that would cut off the negligence of the hotel, but the hotel, in this instance, it was negligent in the manner in which they protected one's privacy. And so there's a lot of interesting legal issues associated with this.
The plaintiffs made two arguments. They had a duty to prevent this. In other words, look, man, if you're staying at the Marriott, you got to have enough security so a guy doesn't know where I'm staying, and he doesn't have the time or the ability to take a hacksaw to my door and take out a peephole. I mean, you guys, what sort of security are you offering here?
None.
Zero. Yeah, exactly. So the point is they had a duty to prevent it. And then once they were aware that this guy was asking what room she was staying in, they said they also had a duty to alert her. In other words, hey, just so you know, this guy has been asking about your room, and he wanted to be put next to you. And the plaintiff said that they had a duty to convey that information.
Yeah, because some hotels you walk in and there'll be the red light on the phone, and then you call down to the desk, go, hey, what's going on? Hey, you got a call or somebody stopped by, they alert you. None of that occurred here, so she was never apprised of the situation.
So the attorneys had to ask for a number, and it's very difficult to ask for a number when it's not accountable. You can't do an accounting. You can't add it up. And most of the personal injury cases we've got loss of income, we've got medical expense, which you can quantify. You can render that to a numeric value. Here, they have to render the subjective to a numeric value, which in this case is general damages, pain and suffering, anxiety, fright, etc. She made a good witness. Apparently, she was compelling, and they asked for $75 million. The jury came back at $55 million, and they said ultimately that the individual, Michael David Barrett, is responsible to pay $28 million of that, and then the Nashville Marriott, and then also West End Properties and Windsor Capital Group are responsible for the remaining 26. So the interesting part is that the parent company Marriott was dismissed, saying that this is a franchisee experience, and the parent company is not responsible for the way that the franchisee runs their particular operation, which was important for Marriott, the general corporation. But what is interesting is West End Properties and Windsor Capital Group, they run a bunch of different hotels. It doesn't have to only be Marriott a bunch. They're basically kind of the arm that runs, the catering and the room service and the hiring and all that stuff. Well, they're big companies, and I don't think they can file for bankruptcy. If it was just a one-off Marriott and they had $26 million, I think they would just say, hey, look, we don't have $26 million. Our liabilities exceed our assets. We'll file for bankruptcy, and it gets discharged. But I don't know if they can do that because of West End Properties and Windsor Capital Group. So they may actually have to pay something.
The bankruptcy laws have changed dramatically in the last decade. They're so much tighter. So, and there might be an appeal. There'll probably be some negotiation at the end of the day, and hopefully they make her whole. And
I think it was either Tim Hodson, who by the way, his father-in-law has got some issues with the surgery coming up. So Tim, our thoughts to you and your family, and fingers crossed. But I know that your father-in-law is a very tough Polish individual that basically has seen much harder challenges than this. So fingers are crossed with an eye towards his speedy recovery. All right, so I think Tim pointed out, or maybe it was my law partner Chris Price, pointed out that the O.J. Simpson matter, where he was found civilly responsible for cutting the head off two people, was only ordered to pay $8.3 million in compensatory damages and then $25 million in punitive. So there was no punitive in this case.
Correct.
is this $55 million compensatory.
Well, you got to take into account inflation.
Yeah. So, I mean, it just goes to show you, that in the O.J. Simpson, we had a $32.3 million or $33.5 million award.